Yo, what's up, YouTube? It's BBcast back again with another video and another reaction. And today's video is part 2 of the Tallahassee Police Department. Basically, this officer right here in the red planted evidence on Calvin Riley wrongfully. She basically opened up a liquor bottle, unsqueezed it, poured it out, and then charged her for having an open container for DUI or DWI, one of the two. And this is the day 1 of the trial, the state of Florida against Calvin Riley, the dude that got wrongfully arrested. So I'm going to watch the trial, get my reaction. Let me know what y'all think about it in the comment section. Let's get into the video.
Today you testified that they were sent to a P.O. box.
Correct.
He did themselves.
I did not.
You didn't actually see the mailing address for the notice.
No, ma'am.
When you called Officer Muth for backup, that's because you already suspected DUI, correct?
Yes, ma'am.
But you weren't 100% certain it was a DUI.
No, ma'am.
In fact, at that point, you hadn't even smelled anything, correct?
I was unsure. Yes, ma'am.
Now, when you were next to the car, you say that you smelled marijuana from the car. Is that correct?
Yes, ma'am.
Because you thought it was a DUI.
Yes, ma'am.
During the search, you found a bottle of alcohol, correct?
Yes, ma'am.
And that was found in a pouch on the front of the driver's seat?
Yes, ma'am.
And the bottle you found in that pouch was 20-gram vodka, correct?
Yes, ma'am.
And it was a smaller bottle.
Yes, ma'am.
When you found the bottle, you took it out, you put the bottle on the seat.
Yes, ma'am.
And you continue then to search the car.
Yes.
During that search, you didn't find any marijuana.
No, ma'am.
You didn't find any joints.
No, ma'am.
You didn't find any paraphernalia.
No, ma'am.
You didn't find any evidence of marijuana besides a smell.
Yes, ma'am.
Before finishing the search, you went back to that 20-gram bottle that you left on the driver's seat.
Yes, ma'am.
And you picked up that bottle.
Yes, ma'am.
You opened that bottle.
Yes, ma'am.
That bottle was sealed before you opened it.
Yes, ma'am.
And so you twisted the top of the bottle.
Yes, ma'am.
And you broke the seal.
Yes, ma'am.
And after you opened it, you dumped out the contents.
Yes, ma'am.
You dumped it onto the road.
Yes, ma'am.
Then you put the top back onto the bottle.
Yes.
And then you put the bottle back into the car.
Yes, ma'am.
You threw it on the passenger side.
I did.
And has that always been your testimony?
Everything that you just asked. I did not know that I opened the bottle in my original testimony.
Now, you see, this is where the bullshit and the lying is coming in from this lady, bro. Because we all know, if you drink, if you drink, you don't, I guess. But anything that's sealed is going to be pretty hard to open. So she's saying that she didn't know that she opened it. But in her deposition, she said that she realized she opened it when she opened the bottle. But then she said something, oh, she didn't realize that she opened it until she watched the body cam. Like, she ain't even keeping up with her lies. And, man, I feel bad for her lawyer. I know her lawyer, like, just scratching his head like, man, I shouldn't have took this.
At a pretrial hearing, you swore to tell the truth, correct?
Yes, ma'am.
And you testified that you didn't unseal it.
Objection, Your Honor.
Overruled.
Yes.
So, at that time, that was a lie.
Unknowingly, yes.
Just say it was a lie. You could get caught at 4K doing something wrong, and they still gonna lie. Like, it's wild.
But now, you know that you did unseal it because you had the chance to watch your body-worn camera.
Yes, ma'am.
But then she said she didn't know she unsealed it whenever she started realizing it wasn't sealed when she was opening it. But now it's, oh, I didn't know till I see my body cam. You see that? There's so many lies. I don't think she care, bro. Like, she really don't. She like, I put that nigga in jail. I don't care. That's a look she giving me, bro. And it's sad that we really, like, there's even a trial for this. I guess because, they asked for the trial or whatever, but I would have thrown her in jail, bro. I hope she gets some time.
Now, Officer Muth was the other officer with you, correct?
Yes, ma'am.
She also conducted the search of the vehicle.
Yes, ma'am.
And as we keep reiterating, you've previously done a deposition, correct?
Yes, ma'am.
And during that deposition, you swore to tell the truth.
Yes, ma'am.
Has it always been your testimony that Officer Muth also searched the car?
I told you at the time I did not remember her searching the vehicle.
Man, one thing about these damn courts, bro, it be so damn boring. I understand this is a real serious thing, and I hope this lady does get time, man. But man, courts, but it be so damn boring, bro. Like, damn, they want to go to sleep because they be pausing for so damn long.
So, Officer Muth wasn't there when you opened the bottle.
No, ma'am.
And officers rely on each other to write reports.
Yes, ma'am.
And that's because not every officer sees everything.
Correct.
And not every officer writes a report.
Correct.
Usually there's a primary officer.
Yes, ma'am.
And they're the ones who write the primary report.
Yes, ma'am.
In this case, Officer Muth was the officer who wrote the primary report.
Correct.
And you told Officer Muth about the bottle.
Yes, ma'am.
And you told her that because she was the primary officer.
Yes, ma'am.
Because she'd be writing the report.
Yes, ma'am.
And you told her about the bottle because you were using it as evidence.
I told her that there was a bottle of vodka found in the vehicle.
Objection, hearsay.
Overruled.
I told her that I found a bottle of vodka in the driver's seat. Now, whether she used it or not as evidence, that was up to her.
It's so crazy how she's like trying to like low key blame the other officer. She's like, oh, I didn't know because it was up to her. She wanted to charge it. But man, it couldn't have me in court, bro. I would have so many damn outbursts.
But she only knows anything about that bottle because of you.
Yes, ma'am.
Objection, speculation.
Overruled.
The judge like overrule. Just keep it to every time you go say objection, I'm gonna say overrule.
So her entire knowledge of that bottle is based on what you told her.
Objection, speculation.
Overruled.
Yes, ma'am.
And an open liquor bottle found inside the car within reach of the driver would be a big indicator for a DUI, correct?
Yes, ma'am.
And you told Officer Muth that bottle was open.
No.
Has that always been your testimony?
I don't remember.
You did a deposition, correct?
I did.
You swore to tell the truth?
Yes, ma'am.
In that deposition, did you say something different?
I don't remember what I said about that.
Man, we talking Chinese? We like what's going on? She lost her memory. She sure ain't remember. I don't remember. I don't remember. Like you gonna remember the time they gonna give you?
Would seeing a copy of the deposition refresh your recollection?
Yes, ma'am.
Bro, her face is like you don't bring that. She's like she really don't want to see that, bro.
Starting state.
Which line and page number?
63.
For the court as well, what page and line?
Oh, that's right here.
You can proceed with your refreshing of a recollection.
I'm searching. May I approach, Your Honor?
Yes, ma'am.
Thank you. Lines 4 through 7.
Yeah, just
Oh,
to
sorry.
yourself.
Thank you. Okay.
In that, did you say that you didn't remember your exact phrasing, but you knew from seeing her
Objection,
report?
over impeachment.
Sustained.
Amendment confirmed, Your Honor.
Yes.
But you agree that she would only know that her that it was open. Did you previously testify that you didn't remember your exact phrasing?
Correct.
But previously you didn't deny telling her that it was open.
No, because I couldn't remember.
But you agree that she would only know that from you.
Yes, ma'am.
I withdraw my objection.
And like you said, she put that in her report.
She put an opened bottle, correct?
And she put that in her report because it was evidence.
I can't say why she put it in her report.
She said I can't see why she bro. Ah man, I could not be in the court system, bro. I would have too many damn outbursts, man. I know you got to be professional and everything. You have to like really do take it serious. I'm just not a serious person. But honestly, it just makes me mad that they're even having a trial for this. But I understand because, you know, innocent till proven guilty. But, bro, I really do hope they give her some years because this stuff got to stop, bro.
The report says that there's an open bottle, which she knows because of you. Correct?
Maybe.
Did you not
Come on, man. Bro, she does not want to tell the truth. She does not want to go to jail, bro.
testify earlier that the only way she would have known that it was open was from you?
Either what I said or what she assumed.
you're denying that previously you testified that she only knew about being ordered
Objection,
because.
improper impeachment.
Sustained.
A moment to confer, Your Honor. Officer Oliver, you previously testified at this trial, correct?
Yes, ma'am.
You've been under oath this entire time that you've been on the stand.
Yes, ma'am.
And you previously testified that the only way that Officer Muth would know about an open bottle was because you told her it was
Objection asked
open.
and answered.
Overruled.
Can you
Correct?
finish your question,
That was the whole question. Do I need to say it again?
please?
You previously testified under oath that the only way Officer Muth would have known that there was an open bottle is because you would have told her that it was open.
If it was said to her, then yes, it would have been me.
Bro, look at her face. She's like, I really like she. Man, just her face expression is honestly the funniest thing to me because she really didn't think that she wasn't gonna get caught. And I really do have a strong theory, my own personal theory. No one has said this is only me saying it, that she probably did this to a lot of other people, and nothing ever happened to them because if she was that comfortable to do it on body cam, that ain't her first time, bro. That's just her first time getting caught.
And you would agree that an empty bottle would be evidence of a DUI.
Yes.
And that's an open bottle that you created.
Yes.
You're the one who made it an open bottle.
Objection asked and answered.
Overruled.
Yes.
So you're the one who created the big evidence of the DUI.
I don't know if she used it as evidence.
She sure didn't know if her body cam was on and off, though.
And after you turned off your camera, you were still speaking with Officer Muth and Sergeant Smith about the case, correct?
If I remember correctly, yes.
But your body-worn camera was off at that point.
Yes, ma'am.
Despite discussing important things about the investigation.
I was no longer with the defendant, so the criminal investigation was over for me.
Evidence isn't part of the criminal investigation.
It is.
And handling evidence is part of a criminal investigation.
Again, yes, it is.
And today, you previously testified just moments ago that you didn't have on your body-worn camera while you were towing the car full of evidence.
I did not
Objection asked and answered.
Overruled.
I did not physically tow the car. I never stepped out of my vehicle. I sat in my vehicle while the car was being towed.
You didn't have your body-worn camera on while you were making sure that the evidence, the big evidence that's in everybody's report, is handled correctly.
Correct.
And you're familiar with Apple Pay, correct?
Yes, ma'am.
So you know of ways that people can pay using
Objection
phones.
relevance.
Sustained.
Mr. Riley told you that he paid with his
Objection
phone.
hearsay.
Overruled.
Can you repeat the question?
Mr. Riley told you that he paid using his phone, correct?
Yes, ma'am.
And you thought that that wasn't true, correct?
No?
Or you thought it was odd?
I did think it was odd, yes.
But you know of ways that people can pay using their phone.
Yes, ma'am.
Mr. Riley never told you his address was 429 West Brevard Street, correct?
Not to me, no, ma'am.
You just assumed that his address was 429 West Brevard Street.
Yes, ma'am.
A moment to confer, Your Honor.
Yes.
Correct. Riley never told.
I ain't capping, man. This lawyer be taking for a minute to get her each of her questions out.
Mr. Riley never told you his address was 429 West Brevard Street. That for David, at his mill. And earlier today you testified that you didn't get his mill initial, correct?
Correct.
And that you would need that for David, correct?
I don't need it for David, no.
But you testified that that's what you used for David,
That's what I use for teletype, which is the dispatcher.
for teletype. And you said that you didn't even ask him for his mill initial, correct?
Correct.
Because you thought that he wouldn't give you his mill initial,
Correct.
despite him willingly giving you his name without any problems.
Yes.
And like you've repeatedly said, the car was towed, correct?
Yes, ma'am.
So it was never impounded.
Not to my knowledge.
Nothing further right now, Your Honor.
Your Honor.
Redirect?
Yes, Your Honor, beforehand, can we move sidebar briefly?
Yes.
Your Honor, if I may actually, the state's more or less referring to the actually, we should probably move sidebar. I'm sorry, Your Honor.
Bro, just how nervous she's looking. Like, she knows. I low-key, I love this, man. I love when they get caught, man. Like, just that, the face is just killing me because no matter what, she knows that she knows she fucked up. And she knows she's a words I can't say, but she's not a good person.
Just a moment, Your Honor.
You see what I mean, bro? I'll be falling asleep if I was in court.
May we?
Yes, ma'am.
Officer Oliver, I want to pick up right where the defense left off. We were just talking about your body-worn camera being taken or turned off after you concluded the criminal investigation.
Objection, leading.
Overruled.
Officer, What big evidence was in this car when it was being towed?
Objection, reading.
Overruled.
I'll ask the question again. What big evidence was in this car when it was being towed?
The only evidence I know of is she mentioned the bottle of alcohol and the cup that was
You mentioned the bottle of alcohol. she throwing the other officer under the bus, bro. You know she a hoe.
smelled like alcohol.
Okay. Officer, was that big evidence to your decision to arrest the defendant?
No.
Okay. Let's talk about, looking aside from this alcohol bottle, let's stick to the facts. What signs of impairment led you to decide to arrest the defendant for driving under the influence?
The signs of impairment that
Objection, cumulative.
Overruled.
the signs of impairment that I noticed myself was the glossy red shot eyes, the slurred speech, confusion when looking for documents, the way the vehicle was driving on the roadway, the swerving back and forth, the obsession speaking about the phone and other things, and then the aggression.
You mentioned something I actually want to touch basis on as well. You mentioned the glasses, or the glossy eyes.
Yes, ma'am.
When you saw the defendant, did he have glasses on?
Yes, ma'am.
Were they sunglasses?
No, ma'am.
Could you see through them?
Yes.
Could you still see his eyes?
Yes.
Okay. Now, I know you mentioned earlier that you didn't notice bloodshot eyes. Did another officer tell you about bloodshot eyes?
Objection, reading.
Overruled.
Did another officer tell you about bloodshot eyes?
Yes.
So, now I want to move.
Bro, she just lied. she said she noticed this and that, and then oh yeah, another officer told. Bro, come on, man.
To another point that you mentioned about fumbling documents. How long did it take the defendant to finally find some piece of paper with his name on it?
I know y'all heard that. Listen how she's breathing.
How long did it take the defendant to finally find some piece of paper with his name on it?
Bro, she knows she screwed up.
From the time the stop started, probably maybe a minute and a half.
And again, did he produce his driver's license?
No.
Now, defense counsel asked you questions about, you believed he had knowledge because he didn't have a driver's license. Can you explain to the jury your rationale behind that?
Yes, so when somebody has a suspended, revoked driver's license and they still have it, we typically seize that and send it back to the DHSMB. So they typically do not have it after that point.
And I hope you do not have a job after this point.
Now that we're talking about the seizure of the driver's license and all that, I want to move to the notices of suspension that we talked about earlier today. Officer, were you able to...
Objection, Your Honor, may we approach?
Yes.
After noticing that the defendant didn't have his... Officer, after noticing that the defendant didn't have his driver's license, were you able to confirm that his license was suspended?
Yes, ma'am.
Okay. Were you able to confirm how many times he was notified of that suspension?
Yes, ma'am.
Can you tell the jury how many times he received notices?
If I remember correctly, it was 3.
Objection, Your Honor, outside scope.
Sustained.
Can you tell us what address those notices were sent to?
The
Objection,
PO.
Your Honor, scope.
Overruled.
I'll ask the question again, officer. Can you tell the jury what address the notices were sent to?
If I remember it correctly from earlier, it's the P.O. Box 1118, I think 5 was the last number.
Your Honor, permission to approach to retrieve the pre-marked exhibit?
Clerk is making a copy of it. We'll go sidebar as soon as she's back to look at it.
Yes, Your Honor. Okay. Defense counsel asked you about what address you had seen at the scene. Can you tell us what originally you thought the notices were sent to?
I originally believed it was sent to the residential address on David, which was the 429 West Brevard Street,
Can you tell us why you assumed that?
because that's the only address given to us on David at the time of the stop.
Now we're here today, we're talking about a different address. Is it you who's saying that it went to a different, or to the P.O. box, or is it somebody else, like the DMV or the DHSMV?
Objection, Your Honor. Calls for hearsay.
Sustained.
Could I just have a moment, Your Honor? The DHS,
It's in evidence. It's overruled.
I'll ask, where did the DHSMV say the notice was sent to?
The P.O. Box.
Objection, Your Honor. Hearsay.
That's referring to a document that's in evidence. It's overruled.
I'll ask one more time. Where does the DHSMV say that the notice was sent to?
The P.O. Box address.
Is the P.O. box address the same as the one on the document the defendant gave to you?
Yes.
Now I want to transition over back to additional signs of impairment that we noticed after you checked for the defendant's driver's license suspension. After you checked for whether or not it was suspended, were you able to interact with the defendant again?
Yes.
When you're interacting with the defendant, can you describe to us how he smelt to you at that time?
He smelled overwhelmingly of alcohol.
When you were searching his vehicle, what did the vehicle smell like?
It smelled like alcohol and marijuana.
Now, I know there were some questions about how you didn't initially smell that when you first met him.
Mm-hmm.
How far away were you from the defendant when you first approached his vehicle?
From the defendant, I would say face to face was maybe about 2 to 3 feet.
Were you able to go inside of his vehicle?
Not at the time.
Were you able to go inside his vehicle later?
Yes.
At that later point, is that when you also realized the smell of marijuana and alcohol?
Yes.
Now, officer, I know you mentioned that you have been, or how, strike that. Officer, was this your first time smelling the odor of alcohol?
No.
Have you smelled it before?
Yes.
Does it have a specific odor?
Yes.
Is it the same smell that you smelt that night in the car?
Yes.
Is it the same smell that you smelt that night when you sniffed the cup that you found in the center console?
Yes.
Now I'm going to transition to the second substance we just talked about. Have you smelt what marijuana smells like?
Yes.
Do you know the difference between raw and burnt marijuana smells?
I do.
So are you able, or does it have a specific odor?
Yes.
Okay. Is it the same smell that you smelled in the defendant's vehicle that night?
Yes.
In your experience as an officer, is it uncommon to come across somebody or their vehicle that has an odor of marijuana and then not find marijuana inside?
Very often, yes.
Now that we've addressed your initial observations and the driving while license suspended, I want to transition to the second part of your the second part of questioning from the defense. The defense asked you about how you went about searching the car.
Yes.
Officer, was the alcohol bottle already in the vehicle when you searched it?
Yes, it was.
Now, I know we already covered this originally, but the defense brought this up, so I want to cover it again with you. When you opened the bottle of alcohol, did you have any reason to believe that it was opened or sealed?
Objection, Your Honor, asked and answered.
Overruled.
I did not know until it was opened that it was sealed.
And I know we also talked about a suppression hearing.
And this is, bro, this is, she said she did not know it was open until it was unsealed. But then she said, I didn't know it was open. I didn't know it was sealed until I watched my body camera. Like, she keeps switching back and forth, bro.
Hearing where you found out about the seal. Did you watch your body-worn camera that night after you opened this bottle or arrested the defendant?
Not to my knowledge. I don't remember if I watched it again.
Did anyone point out to you the audio and the video until the suppression hearing?
No, not until the suppression hearing.
So, is it safe to say that when the defense pointed it out to you during the suppression hearing, that was the first time you realized your mistake?
Yes.
The defense also asked you questions about whether or not you told Officer Muth that it was open. We watched the body-worn camera footage here in court. To your recollection of it, do you recall ever hearing yourself tell Officer Muth that the bottle was open?
No.
The defense also asked you about whether or not Officer Muth searched the vehicle with you. When we watched the body-worn camera footage, could you hear her talking to you during the search of the vehicle?
Yes.
Was she also smelling the liquor in the open Tervis at the time that you were searching the vehicle?
Yes, she did.
Is it safe to say that she was helping you with the search?
Objection, leading.
Overruled.
Was she helping you with the search?
Yes, she was.
Could I have a moment to confer? Your Honor, no further questions from the state.
Okay. Does this witness need to be retained?
Yes, Your Honor.
All right, so you may step down, but please don't leave yet.
Yes, sir.
Which is also, this is also a crazy part, man. This ain't even like, this trial has nothing to do with her. It has to do with the guy that got pulled over. He's the one that's going to trial over this. Like, this has nothing to do with her. So I really do hope that she gets charged after this, because you already know what the outcome's gonna be, bro. It's gonna be in his favor. It ain't no way. It's in video. If it's not in his favor, bro, the system failed us again.
So, ladies and gentlemen of the jury, I've been told that the state has at least 2 more witnesses. So we have options. It is currently 6:20. We can push through. We can break if necessary for dinner and then reconvene and try and get this case brought to a conclusion this evening. Or we can use this as a natural breaking point and return on Monday morning to reconvene.
And I'm not going to have this go any longer than it already has, but basically they're going to come back Monday morning, and that's when they're going to have trial again, day 2, and then figure out what's going to be done as far as the dude, Mr. Riley, that got pulled over, wrongfully arrested too. And it really shouldn't even, I feel like it shouldn't even take 2 days. It should just be 1 day. You know, he's not guilty of all the charges they gave him, and then they bring her in and charge her and fire her, bro. Because there's not no excuse for her to be in the force or to continue to be when it's on clear video of her pouring out the liquor bottle, closing it, and then telling the officers, oh yeah, it was open. And, you know, like, what? It is crazy because, bro, she really trying to, like, go back and forth with her lies. I didn't know it was, I didn't know, I don't remember, I don't, like, Man, y'all tell me what y'all think about this whole interaction. I mean, not interaction, this trial date. I'm getting so used to seeing them damn interactions I be sharing, bro. I be saying that shit. I'm gonna start changing up what I'm saying. But let me know what y'all think about this. This whole, this whole situation with this guy. What do y'all think about the officer? Like I said, my take, I hope she gets fired and charged, bro, because there's no need for that. But it's crazy because this probably ain't even her first time. Just her first time getting caught or brought to the light. So. But y'all let me know what y'all think, and y'all have a wonderful day. And also, I will put a part 2 of this video too, and whenever the trial's over with, so I'll keep y'all updated too. But y'all have a wonderful day. Make sure to like and subscribe.